Health information management has a strong legal relationship. Yes, there's a relationship between health information management and the law. This is because, let's start even with the profession itself. The health information management is grounded on the enactment of the Act. Yes, when we look at Chapter 166 of the Laws of the Federation of Nigeria, we can find where the law that established the profession of health information management. A patient is a citizen that is protected and bestowed some certain rights by the Constitution of the Federal Republic of Nigeria, 1999. Because these rights were also granted to every citizen, such as right to life, right to dignity, right to freedom of speech, right to freedom of worship, right to freedom of movement. All these can now be translated into healthcare community. When you admit a patient, you don't have to force him to overstay. Even if he wants to go, he has the right to go, provided he has, witnesses that will help him, complete the discharge against medical advice. And you don't have to also refuse to allow him movement, because it's about restricting his fundamental human rights, and therefore any attempt to make him not to move away or to move around is like imprisonment, forced imprisonment. You should also know that he has right to his own life. It has granted him by the Constitution of the Federal Republic of Nigeria. Only that right to life is not the same as right to die. Yes, you have no right to kill yourself, even as a patient or a normal person, because killing oneself is a suicide and it's a criminal, offense. But you have to consider all other aspects of the rights of the patient and let him exercise his own, fundamental human rights, because if you fail to allow him, it will lead to a sort of enforcement of his own fundamental human rights whenever he seeks the support and help of the courts. There are some certain doctrines applicable to the law or sourced from the law which try to support health information professional practice. Let's take the case of confidentiality. Confidentiality is also sourced from fundamental human rights of privacy. Yes, confidentiality means secret, and someone's information should be kept secret, and this secrecy is to be supported by privacy. Privacy means right to be left alone, and you don't have to invade someone's privacy. In that same line of supporting privacy, that's when we have a kind of privacy and security of information, and this is also legitimized. It has been made a subject of a law, to the extent that in Nigeria we now even have data protection agency, which is also an enactment of the National Assembly, also as a law, to support these privacy requirements. Within that privacy requirement, arises theory of confidentiality, which try to eliminate or prevent or avoid the encroachment of private health information of the patient. That is theory of invasion of privacy. We try to avoid no encroachment into these fundamental human rights, because these fundamental human rights are also captured in the United Nations Universal Declaration of Human Rights, which seek to enforce all the values of humanity that were lost during the World War. A lot of inhuman activities took place, unethical experimentation without consent, a kind of humiliation of human beings by some group of military and of a particular country, which tend to negate, the values of humanity, etc. So the United Nations came with United Nations Universal Declaration of Human Rights, which seeks to enforce all those rights. We also have some legal linkages to health information management. For instance, Supona Duces Tecum is a Latin word meaning a court order, to produce a health information in court in order for the judge to make a judgment. So when that is done, it's to be served to the hospital, and the attention of the health information officer will be, drawn so that he produces those documents to court, while guarding the confidentiality and privacy nature of that information. So he has to be guided and professionally trained on how to respond to questions in the court. Usually, questions in the court are either yes or no. Don't go with an open sentences, and don't go too deep. Just be professional. Just answer yes or no, and try your best also, even in court, not to a kind of expose the diagnosis of the patient you are trying to produce the information with, except if by situation the patient himself mentioned his diagnosis openly, then that means he has waived that confidentiality clause for himself, and then anybody cannot say out his own diagnosis because he has already said it out. Apart from Supona Duces Tecum, which means an order of the court to produce health information in the court as a record, then we have also Supona Duces Tecum, which means in Latin Supona Duces Tecum, and meaning in English expert testimony or a professional testimony in the court. A judge may also seek the support of an expert to come and make a testimony in the court. So if health information professional is invited to court based on her experience, knowledge, and skills, then he should go and also offer that testimony in order, for instance, maybe to establish a negligence case. Yes, why negligence case? Because negligence means carelessness or action that lacks carefulness. So if a professional committed an act and he's sued for negligence, then the judge will provide an expert in order to measure his knowledge and skills, with that of the person accused of a negligent act. So if the action of a negligent person or the person accused of negligence is equal or surpass the standard of the person that comes to further experts advice or expert explanation, that means it's not a negligence. But if the action of the person accused of negligence falls short of that person that is professional, then it can be termed to be a negligence. That's just one of the criteria, but also in negligence, the judge or the court or the law expects some certain other variables, to be added so that it proves the case of negligence. For instance, a person that will be